Ma me fana say ma PENDREAM TV. PENDREAM TV there osia dem yopo.
Would you why a prosecution a check defense? Say no court. Now time cases say medical charges and medical 78 year. Would it not be so difficult to secure conviction? Would you
school numbers in my community one is prosecutors no almost different strategies. Almost patrolling. I
said walk is deep in the sea. Now the ship back west here. Yes, here. Now the net is so filthy. Net is a Dania. What is a let me a found. Now, a family. It's a Dania.
Prosecutors or different strategies, depending on the kind of evidence or case, investigations on my own. On which matter is okay. With the other charges, they bring a money panel. But good by good. You don't have a copy. Now, Baku cross a CD prana conviction will pay. If it doesn't matter, what I say, if they are charging the panel for stealing 10 million, what I say, Manya 10 million, but Manya for stealing 1 city. Stealing 1 city is still stealing. It is many panel. Please, none of the it is a million craft for stealing 1 city, Manya for stealing 10 million krana. Have secured conviction. It's a very strategies that prosecutors are using. Another prosecutor can say, look, I'm just filing only 4 counts because I believe in my case. And so those 4 counts will succeed. And when those 4 counts succeed, that is good to go. What does I say?
Yes.
So it's all about prosecutors and their prosecutorial strategies. Another thing we can decide, so we don't know the 4 counts, 3 counts, 4 counts, 3 counts. Because I believe in the case, but you see, that kind of, and then there's also one friend because of this sentiment on my about the main kinds of, like I told you, my practice law October will be exactly 13 years and my age May.
Okay.
And I can say, one of the things I've always preached against, said, if you don't have a case, don't take it to court. Don't. Because you see, we should never sacrifice the liberty of an individual because of political expediency. And if you're moving for so that it doesn't matter who the person is, whether NPP new or NDC new, I won't do it. No coming. Not invite you to read 4 judgments, all from the same court. All have been overturned on appeal.
All judgment from the same court, all have been overturned on appeal.
The same court in a way at a force matter. At the end of the day, judgment can say, at a force bears the burden to prove an essential element of the offense. When is it done? What happened?
My name is Simon for Adrian. You want to say the woman while the trial was in process, the woman absconded, and then and then she became a fugitive. Then extradition process na share na fe ya sad number. One of the arguments, the woman was never heard. She was represented by councils or council. Legal arguments.
Can I tell you something? Don't call me. Welcome, majority.
It's your pa.
So, after this particular appeal now, another case you call court in the appeal. First of all, the appeal was filed on the 9th of May 2024.
I was fed up saying now on our way, and then the moon put us on
the film on the moon worker. He just covering his film, the moon worker. He was filed at the registry of the High Court on the 9th of May 2024. Now, when you say, if I lay appeal, I think I'll call the FM settlement of the records. We are not going to, because when you get the whole trial, sometimes it takes 3 years. One concluded trial. If the record of hello.
But Kazo, you too.
If you enter the record of proceeding to compile the record of the photocopying processes alone, it's not a joke. It's not a joke. The volumes are about almost 7 volumes.
Wow.
Bulky documents. So I'm surprised they are telling me every time something. I'm really surprised. But you see, I'm the former attorney now. But sending back court now. The same prosecutors now and the prosecuting and sending at the High Court now. Only the defendant appeal. They came to court to defend their case they prosecuted at the High Court. The same people didn't cheat. The same people who worked under government, the same people who are working today. In fact, after the judgment, at the tail end of the judgment, what I'm not all I so.
What's the power, cousin?
If you are a counsel, Yoda Craig, principal state attorney for the respondent. Now, said you, is it really a principal state attorney 1 year?
Daddy.
Principal state attorney. The prosecutor. Now, you just have to read the submission of the Republic in this. They put up a strong defense of their judgment.
But which here other commentaries be running on it? Some say the essential particulars are in respect of exhibit B. Now, so one they can't, one difference in they left it. One man found come until the appeal court or the appellate court had nothing than to acquit and discharge a Nipan Senina.
Yes, I mean, a bit beyond a better son. Said you, if I said a Nipan is ignorant and now only mischievous. When you beat your Mekasano,
Very.
And me send me back court no. Attorney General office at the application at the pie. Now, we share the affidavit in support of the application. The affidavit is dated 8 May 2026. And listen to what the Attorney General people said. Say that the applicant stroke respondent, after going through the records, have identified 3 missing exhibits which were tendered in evidence before the trial court. That these exhibits relate to the respondent appellant and are crucial for the determination of the instant appeal. That the record of appeal needs to be rectified to include these exhibits, which are 1. A. Exhibit AM, which is the investigation caution statement of the appellant accused dated 20th June 2017. B. Exhibit AM1, which is the further investigation caution statement of the appellant dated 15th November 2017. Exhibit AM2, which is also a further caution statement of the appellant accused dated 21st January 2019. That the absence of these exhibits from the record could affect the determination of the appeal being sought in this instance case. That the applicant is of the firm belief that these exhibits needs to be were put before this honorable court to assist in the determination. Now, black one with you. When the Attorney General filed this application, the Court of Appeal, on the 28th day of May 2026, according to 28th day of May 2026, presided over by Justices Mensa Data, presiding, Emmanuel Senu Amedahe, and Ayuti Ama. Looking to their ruling by court. This is an application of notice by the Republic for the rectification of the appeal record. It has been opposed by the appellant because every time you say the lawyer for me, the application and you say, I tell you, document here come and say, coaching statement, one more the investigators. Investigator mentioned, although Attorney General will control by the investigator. So this exhibit AM2 is already in your possession. And you have it here. So what are you talking about? That's the Court of Appeal. Court of Appeal says, you have to say the lawyers are opposing this application. And so, we are making an order. Also, the council agreed that there is no such mentioned document in the volumes of the records. In the case of the Republic of Zimbabwe and others, the High Court differently constituted. The Supreme Court emphasized the need for discoveries and relevance and admissibility. Since the respondent says that the three documents are the same, and counsel for the applicants admit that they exist, it's the best legal option to have them included in the record of appeal for the avoidance of any doubt that they were indeed tendered, marked, and admitted. On this basis, this court therefore make an order directed at the registry of the Court of Appeal to include these three exhibits, AM, AM1, AM2. The ratification be done at the Court of Appeal.
But when you are going to say, Nanka, as I order the Court of Appeal, order retrial of the matter by a high court. Means what is asking rather than say, we're not saying so.
Usually, I am in disagree with him, violently on air. When a conviction has been secured improperly, it is not a question of mistrial. The conviction itself can no longer stand. Two, Sunday did not say, I was not given the right to be heard. When you say, if the person has not been given the right to be heard, that's the point where you can say, then go back to be heard. This time, the woman herself, she was in the jurisdiction, submission of no case was done, the submission of no case was opposed, and the ruling was delivered. It was later part now, so the greater part of the trial, she participated in it. That's what I say. That option of going back for retrial could no longer be sustained. I, with respect, will encourage my learned senior, Gary, to go back and read the judgment of the High Court. Just apply that to the judgment of the Court of Appeal. And another the castle is, again, Seven has not been treated well. And I said it. It doesn't matter. Look, I can produce full judgment. In my bench, in my bench bank.
I know Beige Bank, yeah.
The same High Court, after prosecution called their witnesses, the same High Court, I can tell me, say, open a defense on all the counts. And I'm like, that submission of no case ruling, also another argument arguing, and I'm Court of Appeal. Look, we should read the brilliant judgment of Justice Edudzi. Justice Edudzi tore the whole judgment into pieces. When I finished, I said it with him. Look, there's a case, don't call me, and I feel so sad. Penny, where I'm Kwame Okufu. Kwame Okufu.
Yeah.
Representing accused persons being our case being two accused persons. Yeah. The two accused persons were convicted by the same High Court and sentenced them to prison. When we say both the Court of Appeal and Supreme Court have set aside the conviction. By the time the appeals were heard, Mama Several on the sentence maybe.
Oh, I don't know sentence and no wasa, and now a chain, and appeal chain.
No, what? It was, I think, they were convicted for 24 months imprisonment with hard labor. And by the time we made process the record of appeal, almost the decision came. Mama said they 24 months now.
Oh. Now, back to the issue I am discussing. My page 37. I want to occur the trial, conviction, and sentencing. Now, I'll say the appellant was present for the greater part of the trial, but ceased to attend when proceedings had reached its latter stages. Blah 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 blah. But there was on 18 January 2022, the High Court held that she has absconded in breach of the terms of her bail and directed her sureties to produce her on or before 22nd December 2022, failing which their recognizes will be forfeited to the Republic. And no naked Ghana. The limit trial judge found both the appellant and blah 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 blah, and also as in respect of conspiracy to steal, the appellant and the second accused were convicted on counts 5, 7, 9, 11, 13, 16, 18, 20, 22. In respect of conspiracy to steal, and also Sano was saying the accused was convicted on count 6, 8, 10, 12, 14, 17, 19, and 21, 23. That's what the basa accounts. Next, almost all the counts, no, they were convicted. But the bar appeal, make page 92, was a harsh and excessive sentencing. Having concluded that the convictions on all counts must be quashed, it is necessary to say no more than this upon the final complaint by the appellant that the sentence was harsh and excessive, but that is by the court. A sentence is not an autonomous judicial order. It is the penal consequence of a valid conviction. Where conviction is set aside, the sentence is deprived of its legal bedrock. The appellate question whether a sentence is excessive is intelligible only by reference to an offense lawfully proved to the circumstances in which the offense was committed. What the bar will say, it will therefore be both unnecessary and conceptually unsound for this court to consider whether the punishment fitted a crime on this appeal has not been established in law. Such an exercise would risk elevating a residual legitimacy to a sentence whose indispensable foundation has ceased to exist. the appellant is not entitled merely to a reduction in sentence. She's entitled to more complete relief, which follows from the quashing of the convictions themselves. In those circumstances, the ground of appeal directed to sentence is rendered moot. I will decline to express any view upon it. Conclusion, it has long been the golden thread running through the criminal jurisprudence that the prosecution must prove the guilt of the accused, and this burden never shifts unless enabling statute or a law has expressly clearly said otherwise. That principle articulated by Viscount Sankey and Wilmington versus DPP. Na mitie nsɛm nyinaa baabi a mama masama wa nyinaa ne sɛ baabi kaa na yɛse wɔkɔtɔɔ yɛ a wɔde buo no bi totoo soɔ no saa kaa na arrangement no mehu sɛ honorable speaker ba abɔntea bɛka sɛ wɔn baayɛ no ɛna wɔn renegotiate contract no ɛna wɔn effective payment na the payment no ɛnyɛ maame no na ɛyɛ afei baabi a wɔde sika kɔma nkurɔfoɔ bi 500,000 no so no were they able to prove say ampa were sika na kɔ because bɛdu baabi no aban foforɔ baayɛ no na wɔn truck wɔn sɛ wɔn de masolfoɔ ka it where in net sɛ ampa sika no okwaji sɛ sika no ɛbae it no doubt bi wɔ hɔ a na ɛwezi wɔ mu ɛnkɔmɔ no deɛ makenkan nyina ɛte sɛn.
It's good that we are raising this issue of honorable sticker. You see, like I said, the charge against Sedi, one of the counts anonymous said, these cars were purchased without lawful authorization or commitment. That was the charge. The prosecutors will prefer a branch a friend Sikai say on testify and yet then a mom. Now, that commission they say in kind what happened under cross examination. But you won't remember. Okay. So under cross examination of Sika in an PW1. They can't PW1 according to prosecution witness what one. And this what happened under cross examination. In particular reference to sticker PW1.
It's your power.
61. PW1. It's OSHA page 8. Page 80. Machocha 2. Page 80. Page 80.
The 80
of volume 3.
Okay.
Of the record of appeal. And the only records now are volumes. It's OSHA page 80 of volume 3 of the record. Now, lawyer for SEDI cross-examine sticker. Now, listen to the questions. Question. You also know from your records that the contract for the acquisition of vehicles have been signed by your predecessor, but not a single cedi has been paid by Maslock. Is that correct? Answer. Yes, my lady. Okay.
What to mu say? Honorable sticker ji to mu say. I send the name now, but Mami said in our Tamakulu, and the second accused, woman Piescabia, and as the Casa Annie, woman effective any payment.
Prosecution, I'm trying to see well. Prosecution, FF PW5. PW5, and Director Finance or Finance Officer Emma Maslock. In the prosecution, Echo Freno as almost state witness. Now listen to what happened under cross-examination, and you can find it at page 294 of volume 3 of the records. Question. Your CEO
Page 294 of the record of appeal.
Yes, at volume 3, it will be a public document. Now, question. Your CEO has specified in this court that they renegotiated the entire contract price. Is that the case? Answer. Unfortunately, I cannot speak on my CEO's testimony. Question. I'm asking you personally. Maslock says that the contract price was renegotiated. Is that the case? Answer. From what the person gave to me, yes. Answer why? Okay. Question. Question page 297.
Page 297, okay.
To page 298 of volume 3 of the records. The same PW5 cross-examination, Director Finance. Question. This renegotiated contract was done how many years after A1 had left office? Answer. I have no idea. Question. But you'll be able to tell the court when the payment was made. Is that correct? Answer. Yes, my lady. You see, so when I can see you, any idea when the renegotiation happened now? Do you have an idea when the payment was made? The answer, also, I mean, now payment, yeah. So, question. When was the payment made? Answer, 2018. Yeah, 2018, now I'm 80 executive.
20 saying?
2018, now I'm 80 executive, Emma Macron.
Yeah, honorable speaker.
Yes, speaker.
Chani.
Yes, sir.
Chani, speaker.
Now, only the interesting thing. At the time when I speak out renegotiation plan, there was no governing board of mass work.
Oh yeah, renegotiations. We are the governing board of Maslock. Now why you say because board need decision and the bill and the war implemented according to governance structure and the idea of the companies in the idea. Aye.
Question. Another question. When you renegotiated the cost of the vehicles with Mark Autos, was there a governing board? Answer. No. Indeed, there was no governing board when we signed Exhibit 4 for A1. Is that correct? Answer. That is correct. Question. Indeed, Exhibit 4 for A1 commenced and ended at your desk. Is that correct? Answer. Yes. We are doing another level. We just had to go back to you for it.
Sikabia and also what the man can say interest and to be clear and almost check and now you say or see there be 1 month for cash and of course our more batuna total filling station and now what G says cano and was some at the horse mamma for this cano a clear buyer available records in the say impo a blast the canon
Dedi kama mamena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.